Okay, so today I want to talk about the duty that the professional rules impose on us to represent our client with zeal. That's one requirement. And the other requirement is we must act as officers of the court. We are officers of the court, there's no question about it. But we also represent clients. And we're told you have to represent them with zeal, but at the same time make sure you don't violate your rule, the rule that you must act as an officer of the court. We find this in the old canon of ethics, and it's come forward into the new Code of Professional Responsibility. The duty to act zealously is obviously inherent to our adversarial system. That's what we do. We fight, and we fight to win. And that's the nature of our court system. So obviously, if you're going to be an advocate and a fighter for your client, you must act with zeal, whatever that means. But here's the problem. Sometimes the zeal to win, you can get carried away with, and you can step over that line. Or now, yes, you've been acting zealously, but wait a minute, too zealously, now you've crossed the line and you've violated your obligations as an officer of the court. The other problem with this is not well defined. If you look at the ethical rules, and if you look at some of the decisions, they're all over the place. So what are the guideposts that you're supposed to follow here to make sure that you are acting with zeal, but you're not violating your obligation to act as an officer of the court? Here's what one of the rules says. Historically, a lawyer is an officer of the court and is bound to work for the advancement of justice while faithfully protecting the rightful interest of his clients. Now, what could be more nebulous than that? You have to be advancing justice, but still protecting the rights of your clients. What does that mean? Nobody can tell you that. But there are some, I would say, clear violations that you can avoid, then at least you know where some of the markers are. And I stress this because sometimes when you get in a battle, especially when you really believe that your client's cause is just, or your client has been mistreated by the other party, a good lawyer, it gets his or her blood boiling, and you want to win, you want to vindicate for your client. There's nothing wrong with that. That's what good lawyers do. But you need to also walk carefully. The first thing I would tell you as an officer of the court is never, ever, even in an indirect way, misrepresent anything to a court. That's one of the obligations that you have as a lawyer, as an officer of the court, is to not mislead the court, mislead on the law, mislead on the facts. Depending on what judge you're in front of, that judge has many, many cases before him or her. And to some extent, the court is relying upon your representations of fact and your representations of law. And it has every right to do that. You're an officer of the court. They have the right to assume that you're not trying to mislead them. Now, obviously, you're trying to spin the facts and the law in a way that's most helpful to your client, but that doesn't mean you have to misrepresent that, especially when you're talking about the facts, because the court doesn't, employ any kind of independent inquiry. It's relying upon your presentation of the facts. And if the court finds out that you've done something to misrepresent the facts, you're going to have some serious problems. What about misrepresentations of the law? Well, that can also be done by incorrectly citing a case. Maybe you're taking a quotation from a case and you are pulling it out of context. You're making it say something that it normally doesn't say. One of the things that I think new lawyers think is, well, wait a minute, I'm the advocate. It's up to the judge to look up the law that I'm citing. A lot of courts won't do that. A lot of courts are relying upon your presentation of the law. And if the court finds out that you've done anything to mislead it as to the state of the law, maybe you cite a case that got overturned, or again, you're twisting the words of another court to make it say something that it doesn't say. When the court goes back and looks at that, it says, wait, this is not what that court said. You've stepped over the line. Now, does the court do its own research? Many courts do their own research, but many courts are initially looking at your presentation of the law, and they rely upon that. Discovery abuse. This is a huge area. This could be a topic on its own, but lawyers misbehave when it comes to discovery. And although the rules have tightened up over the years, especially if you're litigating against a big company, for example, one of the tricks you'll do is you'll serve a discovery demand. You're looking for a specific item, and here comes a discovery, 10 banker box full of documents. What are they doing? Here, you find it. That's the kind of thing, or not responding properly to discovery requests. Courts hate that. And the courts are looking at you as an officer of the court to make sure that discovery process goes as it was supposed to go. And if you're misbehaving, you're not fulfilling your obligation as an officer of the court. The other thing I would point out to you, this is very serious, making accusations against a fellow attorney. You should be extremely careful about this. Your adversary is also an officer of the court. Now, there are times when your adversary does misbehave, is subject to sanctions, and you do have to take action. But before you do it, before you file a motion for sanctions, boy, think about it twice, think about it 3 times, maybe talk to other lawyers about it. What do you think before you do it? Do not be so ready to file that motion because you're an officer of the court. So I'm sorry that this is kind of nebulous, but this is what you're going to have to deal with. The tension between zealously representing your client and conducting yourself as an officer of the court. If you keep these benchmarks in line, you'll kind of know where you're crossing that line.